Here we're going to be talking about ABA Formal Ethics Opinion 21-497. This is about conflicts of interest that involve materially adverse interests. So let's dive in. Two of our conflicts rules use the phrase materially adverse interest to describe situations in which a lawyer cannot provide representation without obtaining informed consent in writing from each affected party. These are Rules 1.9a, which is about a lawyer's former clients, and Rule 1.18, which is about duties to prospective clients, that is, people who had an initial consultation with the attorney during which sensitive information was shared, but then no representation ensued thereafter. So note that these two rules are very important, and they actually come up constantly in practice for lawyers. In 2021, the American Bar Association published a formal ethics opinion, number 497, to provide a definition, or at least clarification, of what we mean by materially adverse interests under these two rules. Rules 1.9a and 1.18c cover conflicts of interest that arise when a lawyer wants to represent a new client, or maybe handle a completely new matter for a current client. And sometimes the new matter poses conflicts of interest or client interests that are materially adverse to the legal interests of a former or a previous prospective client on the same or substantially related matter. Unfortunately, neither rule specifies what counts as materially adverse. And that's what this ethics opinion addresses. So first, let's talk about clear cases where the client interests are materially adverse, because the opinion lists several examples. First, negotiating or litigating against a former or prospective client on the same or closely related matter, like switching sides in the same case. Attacking work done for a former client. Cross-examining a former prospective client, usually, because when you cross-examine someone, you bring up information to try to discredit them. But what if the former client is not even a party to the current matter? Note that the representation could be materially adverse to a former client, even if the client is not a party to the current matter, as let's say when a lawyer is attacking their prior work for a former client, like trying to help someone get out of a contract that the lawyer drafted previously for the other party. Now, let's turn to some situations or examples that the ABA says do not pose a conflict of interest. Neither generalized financial harm nor a claimed detriment that is not accompanied by demonstrable and material harm or risk of such harm to the former client's interests would suffice. So, as with our other conflicts rules, the fact that a former client operates, let's say, a rival business to the new client does not in itself count as a materially adverse conflict of interest. So even if the new client you're helping will end up, let's say, cutting in on the profits or market share of a former client, that's not a conflict that would require disclosure and consent. The same is true if the new matter might result in, let's say, setting or changing legal precedent in a way that will end up causing some issues someday for your other client, your prior client. A claimed detriment without, quote, demonstrable and material harm refers to things like the former client's feelings being hurt, or the former client saying it's the principle of the thing, which may just mean they resent the other party's success. Now, let's talk about the problem of cross-examining a former client during trial. Courts sometimes find material adverseness when a lawyer tries to examine or cross-examine a former client, even where the lawyer doesn't use information from the prior representation or the information has become generally known or public. So, to be on the safe side, in these situations, the ABA recommends having the current client retain separate counsel to examine the former client and screening the lawyer with the conflict from participating in the examination of the former client, and no sharing of information about the cross-examination. You can do the rest of the trial, but you switch with another lawyer for the part where your former client is the one who must be cross-examined during the trial so that you're not doing it. Why? We're just worried that some information you have would give you an unfair advantage in discrediting them. Now, as a side note, remember that if your case involved cross-examining a current client, that would come under Rule 1.7. And the lawyer or law firm could not solve it just by switching lawyers for that part of the trial. You would have to get both clients' consent in writing if you're cross-examining somebody you currently represent. This ABA ethics opinion, remember, is about people from your past. Now, let's talk about consent and waiver. Rule 1.9 and Rule 1.18 both allow a lawyer to proceed with representing a current client against a former client or prior prospective client if the lawyer obtains informed consent confirmed in writing. So authorization, let's say, to disclose or use confidential information would also require such consent and is not automatically included. Let's talk about a few real cases that the ABA discusses as examples in this ethics opinion. I find these helpful. You don't need to remember these for the exam, but they will help you understand. So the first is Zerger and Maurer versus the City of Greenwood. In this case, the city brought and settled a nuisance claim against a local rock quarry over truck traffic. The settlement provided that the city could designate specific routes for the quarry's trucks would take. Rock trucks make a lot of noise and dust and so forth. The same firm that represented the city in this litigation then brought a private nuisance action against the quarry on behalf of homeowners around the new truck route designated by the city. So in other words, homeowners were mad that there were these gravel trucks going and rock trucks going in front of their house all day. So in this case, the city was not part of the private nuisance action, but they intervened to ask the court to disqualify the law firm, their former firm, from the case. And the court agreed. The court disqualified the law firm, saying that it was advocating a position that contradicts a term in their prior client's settlement, that is, the city. The next example is the case National Medical Enterprises versus Godfrey. In this case, there was a hospital that faced criminal and civil liability for mistreating patients and for defrauding insurers. A firm had represented one of the hospital administrators and who had denied wrongdoing and actually was never charged criminally, and the civil cases were dismissed with regards to that administrator. Now, at some point, this firm withdrew from representing that individual. Now, later, the same firm sued the same hospitals on behalf of a large group of former patients. So even though the hospital administrator, the former client, was not a part of the case, the court disqualified the firm from this new matter because adverse information about the individual was too likely to arise. In other words, they probably had confidential conversations with that hospital administrator, and they could get dragged into this case. Now, the ABA also cites a counterexample for purposes of clarification. I've omitted the case name for this in my slide, but the facts are enough for our purposes. In this counterexample, a lawyer represented a company that was exploring a potential claim against another company over a defective product. So they bought something from a supplier and it didn't work, it was defective, and they were thinking about suing them. The client decided not to bring the case to preserve the otherwise lucrative commercial relationship. They actually didn't want to alienate this supplier. The lawyer, though, later represented the retired founder of the company in an unrelated claim against the same defendant. And here there was no conflict of interest because the cases weren't really related. The nature of the representation was completely unrelated, so we didn't have concerns. And that concludes our brief lecture about materially adverse conflicts of interest and ABA Ethics Opinion 497.